SJC-13846 in the matter of an impounded case.
Do we have everyone? Okay, Attorney Lamanna.
Thank you. Good morning. May it please the court, I represent the appellant in this matter. The Superior Court has an explicit grant of jurisdiction to review agency decisions pursuant to both the Administrative Procedure Act, Chapter 30A, as well as Chapter 231, Sections 1 to 2. Here, the Department of Children and Families Fair Hearing Officer had the authority to reverse a decision regarding the removal from the appellant of children from her kinship foster placement. The department asserts that the authority to reverse a decision for removal does not include the authority to effectuate that removal. And I would respectfully suggest that the statutory scheme clearly indicates that the Superior Court did indeed have that authority. The mischaracterization of the relief sought by the appellant's complaint in the Superior Court as a request to have the Superior Court make a best interest determination of the children is...
Counsel, I hate to interrupt you right off the bat, but that first premise gives me some issue. What does the fair hearing then process become if they don't have the authority after the adjudication to reverse the decision? And if we follow what you're saying, that the best that you get is now a de novo hearing, what does that do to the due process implications that, you know, you want process, you have your hearing, and at the end of your hearing, you're vindicated, and at the end of your vindication, you get nothing?
I agree with you completely. That's the department's argument. What it does is it renders the entire regulatory scheme completely illusory, and there's no support in the department's regulatory scheme for that contention. The words de novo review, post-fair hearing, don't appear anywhere in the CMRs. The words de novo review, and the department says clearly and plainly in their brief, what she was entitled to after she won was a de novo review. Where does it say that? Where do the regulations provide that? They do not.
Sorry, you were going to tell us exactly what the request for relief here was, and could you tell us exactly what the request for relief is here, and ideally link that to both the declaratory judgment statute and/or 30A?
Certainly. So the request for relief here is under 231, under the Declaratory Judgment Act, to enjoin the department from refusing to enforce its decision and to enforce the decision itself.
So usually, I mean, there are legion cases saying that the Declaratory Judgment Act should not be used in individual administrative proceedings, and it's only where to challenge government practices and policies that are consistently repeated. So can you respond to that?
Yes. So the main problem, of course, faced by this appellant is she had no other process available to her. As Justice George has just pointed out, there is no appellate process within the regulations for someone who has sought a fair hearing, won that fair hearing, and then been told by the department, we're not following it. She had no right to appeal that clinical review that they conducted. So her only recourse was to go to the Superior Court. Chapter 30A was not available to her because she wasn't aggrieved by the decision. So her only recourse was pursuant to Chapter 231 to ask the Superior Court to utilize the jurisdiction it is clearly granted by Section 1 of 231 to enforce the agency or enjoin the agency from refusing to perform its acts. It is certainly true that this is not something, at least in my experience, that is commonly occurring at DCF. I have not seen this before, but I think it is clearly encompassed within the grant of authority to the Superior Court by 231, Section 1.
If we were to accept your view, your reading of the hearing officer's decision, and let's assume that DCF disagreed with that decision, what should DCF have done in your view?
what DCF should have done, because within their own regulatory scheme, there was a mechanism for them to challenge the fair hearing officer's decision, and that's 110 CMR 10.29, which explicitly says that if the department is aggrieved or does not agree with the fair hearing officer's recommendation, the commissioner has 21 days to review that decision, indicate why it was wrong, and make a different decision, which of course at that point would have become the final decision of the agency, and the appellant in this case would have had the full remedies available to her under Chapter 30A.
I think they were alleging that that's what they did, right, through that meeting that they had, the
No,
subsequent
they are not.
meeting.
Respectfully.
No, all right, I'm mistaken, that's fine.
no.
I'm often mistaken.
So under 10.29 Section 3, after 21 days, if the commissioner of DCF or its designee does not take any action in contravention of the recommendation of the fair hearing officer, that decision becomes the agency's decision. And that's what happened here. What they're saying they did is after they ignored the process available to them to challenge the fair hearing officer's determinations, they had the right to convene a closed-door meeting months later, make a different determination, using, by the way, much of the evidence that was considered, addressed, and discussed in the fair hearing officer's decision. They just made a different decision. It was a decision that they didn't have to notify my client about. She had no right of appeal. The regulatory system does not offer her the ability to seek a new fair hearing to challenge that. She had literally no remedy other than what she did here, which was to seek enforcement via the declaratory judgment.
So as a practical matter, it seems like your declaratory judgment action was seeking in order that the agency enforce its own decision.
Yes.
But time had gone by between the removal of the children to the Canadian maternal aunt and the rendering of the fair hearing officer's decision and the 21 days. As a practical matter, what is, so the children are in a different place, right? You know, they have grown, you know, it's not like they're widgets, they're people, and, you know, so what is the agency to do in your estimation?
So there are 2 points that I'd like to address as a preliminary to answering that. One of which is that technically, under the regulations, the decision was supposed to have been issued within 60 days to address, I think, exactly that concern, that children grow and change and their needs grow and change. And justice delayed is justice denied. And in this case, of course, the hearing concluded in September of 2023. The decision wasn't rendered until May of 24, through no fault, certainly, of the appellant. And so that is one concern, that because the department's fair hearing officer did not render that decision within 60 days, by the time the decision was entered, a number of months had gone by and some things had changed for the children. But the one thing that hadn't changed, of course, was that the appellant was still in the same position, which is, as the fair hearing officer found, an appropriate caretaker for the children. And it was in the children's best interest to be placed with her. So the question becomes whether or not, because of the passage of time, the fair hearing decision becomes a nullity because the department now has the right to reassess where the children are. There's nothing in the regulatory scheme that says that that is the case. And of course, that brings us back to this core issue of what process is remaining to the appellant.
Well, there's nothing in the regulatory scheme, and I'm sensitive to that first issue. But there is still the guiding principle of what's in the best interest of these children. And so, you know, you used, I believe the term used was status quo ante.
In the brief, I referenced the
Okay,
statute.
so if that's the lens, well, the principle then for the department is placement decisions that focus on the present circumstances of the children and the current needs of the children. And so we still do have to grapple with, even if you're right, and I'm sensitive to this procedural quagmire that your client was in. But all of that said, our guiding principle still is now, what's in their best interest now? So just doing a retroactive, hey, return the children to the grandmother, that it's not that simple.
It's unfortunately, because of the passage of time, not that simple, and certainly now, because now we're even further removed from the time when the decision was made. But I would also respectfully suggest that the department's attempt to justify their refusal to abide by their own decision went back over all of the evidence that had been considered and offered before the fair hearing officer. There was no new evidence before.
I thought the record suggested that there was things about, the physical ability of the grandmother versus, there was something that talked about limitations beforehand because of cancer-related treatments, and nothing was mentioned subsequently to that. I thought there was some differentiation in the evidence.
That was an attempt by the department to make it look like new evidence, but they had because my client didn't have the children placed with her, was no longer an active kinship placement. The department received, between the time of the fair hearing, the conclusion in September of 2023, and the department's behind closed doors meeting, changing the decision, no new information about my client's medical history. And in fact, my client offered at the fair hearing significant information, including a letter from her doctor indicating that while she had had some physical limitations, while she was overcoming her cancer, those were no longer still in play. So it was the department regurgitating old evidence.
So September 2023, the last information we have about what would be best for the children?
Well, first of all, I'm quite sure that information has been gathered about what's in the best interest of the children in the impounded care and protection proceeding that we don't have access to. So my client has no ability to challenge any of that evidence. To the extent that the department says we conducted this secondary review after we lost the fair hearing, and we decided we were right, and this is why, my client had no ability to cross-examine any of the witnesses that they relied upon or challenge any of that evidence. But I think that goes back to this problem of the lack of due process afforded to my client, because if the argument now is, all right, at the conclusion of the fair hearing, you may have been in a state where you could, as the fair hearing officer found, which is the final decision of the agency, it was in the best interest of the children to be with you. That might not be the case now. That would open the door to my client having an opportunity to be heard, which she does not have.
So what in your view would be the relief that we could afford right now? We would determine that the Superior Court had jurisdiction, and then what?
So the Superior Court, the grant.
Because it's not going to be an order to return the children to the grandmother.
That would be lovely, but absolutely.
It's not going to happen, right?
Now.
So what would we be saying?
So you would be saying that the final decision of the agency, that at the time of the rendering of the decision in May of 2024, it was in the best interest of the children to be returned to the mother. The burden would shift to the department, to the grandmother, excuse me. The burden would certainly shift to the department at that point to demonstrate that that was no longer the case. But the problem, of course, is what process is available to my client for her to participate. She has filed a guardianship petition at this point.
Is that in the juvenile court?
It is. It was filed in the probate court, but we've had another interdepartmental assignment back to the same judge who had, so.
I think that's not going to be the natural instinct, is that these matters involving a single set of children will not be decided by different judges in different courts.
I think that's certainly appropriate, except for the fact that the care and protection matter at this point is in the post-adjudication phase. The children have been determined to be in need of care and protection. Their mother is deceased. Their father stipulated to a termination of his parental rights. So now the guardianship proceeding is essentially a de novo proceeding. My client should have the ability in that proceeding with fresh eyes to prove her case.
So if she's got that, then is there any need for some kind of independent relief through this action?
I think that there is. And the reason there is still a need for the department to be bound by its decision is the department's decision is evidence of the department's record, and that is admissible in the guardianship proceeding. And the ability of the department to ignore the decision for all of this time and then take the position now that so much time has passed, there's no relief available, aside from just the fundamental unfairness of that, is that the department's records still should reflect that the last decision was that it was in the best interest of these children to be with this person.
Sorry, can I ask you a question about that?
Certainly.
So why, can you point to anything in the decision, or why do you think that the decision of the hearing officer was that it was in the best interests of the children to be in your client's care? I read the decision as saying that the department had not followed its own regulations and rules when it determined previously, at that point, many months previously, unfortunately, that when they had made their determination at time X. I didn't read the decision. It doesn't read as though it's a lengthy decision about what is in the best interests of the children now.
Well, the fair hearing officer does say, and relies extensively on the fact that my client had an in-home clinical person, a referral that was made by DCF, and that person had nothing but glowing things to say about her ability to address the children's trauma, her physical abilities, the loving and warm nature in which she dealt with every single person, by the way, involved. That's a specific finding by the fair hearing officer, that the frontline social workers and the area program manager, the actual people working with this woman while she was caring for these 3 children, had nothing but laudatory.
But I there was a lot of stuff to that effect, and I read that and I understand that. But to me, what the conclusion of the hearing officer seemed to be that at the time that DCF made its decision to remove the children, it had not followed its own procedures and standards. I didn't understand it as a decision that as of, was it May 2024, that it was in the best interest of the children to be with the client, with your client. Those seem like different propositions.
She says and this is on the record appendix, page 37, she says, the evidence simply does not suggest that it was in the best interest of the children to be moved away from their grandmother, who had been involved for several years in their day-to-day activities. And then she goes on to all the wonderful things that the grandmother had done, including accessing activities for them, maintaining their care and their relationships with other people. And the sentence preceding what I just read was, there was no evidence submitted that the placement of the appellant was anything other than safe, loving, with friends, peers, and therapeutic
Does the
providers.
hearing officer have authority to determine the best interest of the children?
That was the specific.
Is that in the regulations anywhere? Because it seemed to me that the hearing officer is charged with determining whether the department's decision was made in conformity with department regulations. Because I thought the best interest of the children determination was always conferred to the court, ultimately.
It is ultimately, at the end of the day,
Right.
absolutely.
And the hearing officer is not normally making that determination.
Except specifically under the authority with regard to the removal of children from a foster home. There's a specific statement that the first thing that should happen if the foster parent appeals is that that decision for removal should be stayed. So there's presumptively, within the regulatory scheme, a power by the fair hearing officer to maintain the status quo. And that the burden shifts to the department at that point to demonstrate that it's not in the children's best interest for that to happen. So encompassed within the review by the fair hearing officer of this particular type of appeal is not just the procedural question, did you issue the correct notice, did you do this, but was your decision, did it meet the standards of 7.101 in terms of what's in the best interest of the children?
Okay, thank you.
Thank you very much.
Attorney Fisher-Goban.
Good morning, Your Honors, and may it please the Court. Phoebe Fisher-Groban, Assistant Attorney General on behalf of the Department and Children Families. This Court should affirm the Superior Court for 2 reasons. The first is that this complaint seeks a placement determination.
Does it? It doesn't. I'm sorry to interrupt you so quickly, because it seems like that's the crux of DCF's position, is that the complaint sought a placement decision. And I see the complaint as requiring DCF to comply with DCF's own placement decision.
Your Honor, it does seek a placement determination. And the reason why is because although it seeks declaratory relief and injunctive relief, the face of the complaint is clear. And here I'll cite paragraph 4, paragraph 40, and also the appellant's opening brief. The relief that's sought is placement of the children because the declaration that's sought is that the department has not complied with the fair hearing decision by refusing to place the children with the appellant.
Right, so the department has failed to comply with its own decision.
And then I'll get to the second. So I think this is related to the second reason why the Superior Court should be affirmed here, because the decision.
What is somebody to do when DCF's internal employees refuse to comply with the agency's final decision?
Here, the fair hearing officer was deciding a limited question, and that was whether the evidence in May 2023 supported the department's decision to remove the children. A placement determination is a different determination that is also governed by the department's
That
regulations.
sort of seems to make the argument on behalf of the grandmother. She's not, you're saying these are two different things, right? The placement decision and the fair hearing officer's final decision.
That's correct, yes.
And she's seeking to enforce the fair hearing officer's final decision, which is the agency's final decision.
That's right. And
It has implications as to placement, that's true.
what the appellant is entitled to hear and what she received is a new placement determination in light of the fair hearing decision. And here's why that's important.
Why is that?
That is because this is a child welfare issue. Placement determinations need to be based on the current best interests of the children.
What was the different evidence that the subsequent committee considered that was not before the fair hearing officer?
I would point the court in particular, and mindful that this is an impounded case, to page 58 of the record appendix that discusses current circumstances of the children and why that post date the evidence that was in front of the hearing officer, and which is why the department, in addition to all of the other evidence in the new de novo decision, why the department decided to make a different placement decision.
Can you
They
go
had
back?
a chance to do that within the period of time governed by the regulations, right? So the fair hearing officer makes a determination, and the department did nothing with it within the time period.
That's correct. And so it is the final decision of the department, but that's where it's important what the difference is between what the fair hearing decision means and the authority that the fair hearing officer has and a new placement decision in light of the current best interests of the children.
So I'm looking at the regulations, and the fair hearing officer has the ability under the regulations to reverse the decision of the various DCF employees to remove the children.
That's correct.
And what does that mean in your reading of reverse means a de novo hearing?
The meaning, indeed.
What is that coming from? Because the regulations also say that the agencies who made the initial decision, agency officers who made the original decision, can also reverse their decision. And so the regulations seem to use the word reverse to mean exactly what grandmother is saying, which is return things to the status quo ante.
In this case, that is not what reverse means, and that's because
So it means different things in different cases.
in a child welfare case, which must be based on the children's current best interests, it means that then the previous decision was not in accordance with the department's regulations. That's what the fair hearing officer decided. And so the department needs to make a new decision in accordance with its regulations. The fair hearing officer, while the fair hearing officer—
Where does that come from? You keep saying this whole de novo kind of world once the fair hearing decision is made. Where specifically in the regulations does it say we go back to square one for a de novo hearing? Not what you think it means, but where does it say that?
Your Honor, you're correct. It doesn't use those words. But the regulation governing placement determinations, which is 110 COMAR 7101, is the regulation that governs where children should live. And that determination is based on their current best interests. And the fair hearing decision does not make a determination of what's in the children's current best interest.
But if the timing circumstances are of what your sister describes, in that within a certain amount of time, it's still contemporaneous. So this idea that, the department wants to move the children from their kinship placement, grandmother objects and avails herself to a right to a fair hearing. The fair hearing decision is made in her favor. And so, according to what Justice Wendland just read to you, that the officer has the right to reverse that decision by the department, which means status quo ante. And that's the world that we're looking at the children at the time. At that time, it's their present circumstances. It's not a year later, 2 years later. It's at the time that the decision was made.
The decision was made based on the evidence that the department presented at the hearing in support of their decision to remove the children.
Right.
So it was based on, at that point, the evidence from May 2023.
Right.
And in the intervening period, there were significant developments.
The intervening period to what? To all of this procedural wrangling now with the grandmother trying to figure out a way to stop what the department was doing?
The intervening developments are that since the children were removed in May or June 2023, since then the care and protection proceeding has proceeded apace. The father stipulated to termination of parental rights. The children have gone to different placements, and the department now has permanent custody. So in all of that time, there have been significant developments in the lives of these children.
But I guess the frustrating part is that was created by you, the department, because the children were removed from the grandmother's care. So all of that time where all of this new development could happen was because the children were taken from her. But that leads me to a related point. So with respect to the decision of the fair hearing officer, the department didn't do anything with that, right? So they didn't go to the Superior Court under 30A. They didn't try to seek a determination that hearing officer's decision was wrong in any way. What do we do with that?
Well, Your Honor, it has become the final decision of the department, but that's because the department is going to now make a fresh de novo determination of what is in the current best interest of the children.
And what gives them the authority to do that without complying with the hearing officer's decision, which would necessarily implicate returning the children?
The hearing officer's decision doesn't order that the children be returned.
I understand that, but it reverses the previous decision.
That's true.
So if we were to read it to mean that it at least implicates that the children are to be returned to the grandmother because of a failure to comply with the regulations. And I'm just looking for some legal authority for the proposition that DCF can disregard that while it does a de novo review.
The new decision does take into consideration the fair.
I'm not asking about what that did. I'm asking for legal authority. Is there legal authority that would support DCF disregarding the hearing officer's decision while it does a de novo review? I'm looking for statute, regulation, case, legal authority.
I understand. And what I'd like to point you to is the department's regulation on placement determination.
So you're saying that there's two regulations that may not quite fit together as we're trying to make them fit together?
Well, what I'm saying is that there are two interests here. There is the foster parents' interest, which they have regulatory interest. They're entitled to a fair hearing and a decision. And then there's the children.
Understood. Okay,
Yes.
so we have the children, and I'm not sure that that's what we're talking about in this particular case, right? We're talking about the hearing officer's decision and being here at the Superior Court's decision that they don't, that he didn't have jurisdiction. Why do you care that? Why shouldn't you be on the side of allowing the decision to be approved? Why shouldn't the Superior Court have jurisdiction? I don't understand why you're fighting that if it doesn't have anything to do with the placement of the children.
Because the relief that's being sought here is the placement. And I also want to answer this question by getting to the second reason why the Superior Court should be affirmed, which is that it lacks the power to order the placement of children because there's an existing proceeding in the juvenile
What
court.
if we just said the Superior Court has the right or the jurisdiction to look at this appeal and decide it? And if it doesn't have anything to do with the placement of the children, then that's how it is. That's the case. I don't get it.
On the face of the complaint, this complaint is seeking placement of the children. And I also just want to note, we've already discussed, this foster parent has other remedies, the guardianship petition in juvenile court, and also in the care and protection proceeding, the children who you'll hear from in a minute could always take the fair hearing decision and bring it to the juvenile court and say, juvenile court, we are filing a motion for an abuse of discretion, that the department has abused its discretion of where to place children in its custody by not placing us with this foster parent. They have not done that. That is the
Grandmother have done?
Pardon me?
What should the grandmother have done? What did the grandmother do wrong here?
It's not a matter of the grandmother doing something wrong, but it's a matter of the children's best interests becoming first. And those are the current best interests. And those are decided in the care and protection proceeding. And the Superior Court doesn't have the authority to override the placement decisions that the department is making subject to.
But that's the thing. You're saying the Superior Court would have to override the agency's decision. And the agency's decision is that the kids should be with grandma.
The agency's decision is not that the
It is because it became the final decision of the court, of the agency, when the 21 days lapsed and nobody did anything about it.
And you said as much 5 minutes ago, that it was the final decision of the agency when it came to the fair hearing.
So, I mean, a different way of viewing this case is not that grandma is trying to force a placement decision contrary to what the agency wants, but that actually the agency's employees have gone rogue. And the agency's final decision is that these kids should be placed with grandma. Not just for now, right? Like not forever, but for now.
Your Honor, the question in front of the fair hearing officer was whether the grandmother could demonstrate by a preponderance of the evidence that the department had not followed its regulations in May 2023. The current decision of the department is reflected in the record, and that is the new placement determination it made in light of the fair hearing decision and in light of the intervening circumstances.
You're saying that
family and this
the
children.
intervening circumstances are found on page 58 of the record.
Yes, and also in the entirety of the new decision, which talks about.
Well, I read the whole new decision, and there's nothing in there that wasn't considered by the fair hearing officer.
But there is additional evidence in that decision, and that supports the current decision because, again, the department.
You think if I do a side-by-side between what the fair hearing officer had and what this new de novo hearing considered, there's a difference?
Yes, and I'll also point out one other important difference. In the fair hearing decision, in the reference to the exhibits that the department had, there is a particular report that was sealed, and the department wasn't able to get it released by the time of the fair hearing decision. So that's a specific document that wasn't in front of
Anything else, though?
That wasn't in front of the fair hearing officer. And then there's
Anything else besides that report?
that report was a key exhibit. I can't confirm in this moment what else was there, but I can emphasize these two things. The first is that in child welfare cases, the placement decisions, according to the department's regulation and the department's statutory charge, must be made in the children's current best interests.
Can I just stop you there? I
Of course.
completely understand that. Why isn't it proper procedurally for this court to make the decision that, yes, it should go back to what the department's decision is, which is whatever the fair hearing officer decided. And then the department takes that and says, okay, but we've got these other regulations that talk about placement and the current best interests of the child. I mean, isn't that how we go about it step by step?
Respectfully, Actually, no, for two reasons. Because this comes to the court from an appeal from the Superior Court. And the Superior Court here concluded that it didn't have jurisdiction to
If we say that it did,
that
right?
the Superior Court, but in this case, the relief that's being sought is the placement of a child.
Isn't that different than subject matter jurisdiction?
Well, it's the power to.
No, I mean, that's what we're here for. The trial court in the decision said, I believe, that they had jurisdiction over the claim, but not the relief. Isn't that different? Even if, isn't that a different question than subject matter jurisdiction? That you can't afford the relief versus have the ability to hear the claim?
Well, the Superior Court, of course, has jurisdiction to hear declaratory judgment claims. But this complaint is seeking something quite narrow, which is to place the children with this foster parent.
Well, it's also, the complaint is also contesting the department's interpretation of its own reg as allowing as reversal equals new de novo decision. Why is that not something about which the Superior Court could opine under the declaratory judgment statute?
The Superior Court can make a decision under the declaratory judgment statute about inconsistency of the agency's actions with respect to.
And isn't that exactly what the complaint is highlighting here?
This complaint is asking, again, I must emphasize paragraphs 4, 40, and the appellant's opening brief are saying that the issue here is refusal to place. And so a declaration of rights here would say that the department must place these children with this foster parent. And that it would override the department's placement determinations in the care and protection proceeding that's in front of the juvenile.
It couldn't be read differently. It couldn't be read that the department should not have placed the children in the maternal aunt. Not the way you phrase it, but that we're saying the opposite, that the department should not have removed these children. Now we're asking you to return them, that you shouldn't have moved them in the first place. And that's a different thing.
But I'm not certain where that relief leads, because
Well, it leads to us not buying that they're looking to make a placement decision. They're saying you should not have removed in the first place. So that's very different than coming in and saying the children are in X and we want them to be in Y.
But the remedy for that would be a current placement decision, which is what has happened. The remedy for saying the department has made a mistake is that they have to look at the children's current best interests and say, okay, we need to figure out where these children should be placed now.
That's right, and you would do that.
That is exactly what the department has done.
Yes, but you've skipped over, where's the remedy for violating your own regulations? You can't answer.
Well, the remedy here is that there's a fair hearing decision saying that the evidence as of May 2023 didn't support the removal of the children.
Right, and nothing was done with it. And then the grandmother did the only thing she could do, which was bring a declaratory judgment action before the Superior Court. And you're saying that no, but you can't do that.
Well, the department did make a new placement decision in light of the fair hearing officer, but there are other remedies, which the children who this is about, they can take action in the juvenile court, and the grandmother here can seek guardianship, which she has also done. So there are other ways to use this fair hearing decision that are all in the children's current best interests.
Thank you.
Thank you, Your Honors.
Attorney Russell.
Please the court, Attorney Morgan Russell on behalf of the children, the appellants. I first want to briefly just address the amicus brief because it assumes consolidation of these two matters, and that did not occur here. It assumes that because the sitting juvenile court judge was interdepartmentally assigned to the Superior Court case, that it merged the cases, and that's not what occurred. If the court is inclined, I can submit the docket of the CNP as well, just to supplement and show that there was no motion to consolidate. It was just an interdepartmental hearing that occurred.
Well, I don't think grandma could consolidate.
I agree. And I think,
Okay.
yeah, I agree, absolutely. And that's what is truly at issue
I
here.
mean, I thought the point of the interdepartmental placement or move was so that the same jurist who was in the CMP could consider the DJ. So that we wouldn't have two disparate decisions by people who didn't know what the right hand and left hand were doing.
Correct, but I think that to as the amicus did, that they were consolidated, that the sitting as a Superior Court judge, he's using the evidence of the CMP to make this decision, I think is dangerous, because of course it would have been,
But the decision is just subject matter jurisdiction.
that is what ended up happening, that's correct.
Okay.
I just wanted to address the amicus point on that, because I think they,
So why didn't he have subject matter jurisdiction?
I would echo what my sister just argued, that the relief sought, no matter how you call it, it's really semantics versus what the substance of the request is. And that substance was, we'd want these children placed with the appellant.
Which is the agency's final decision.
It was. But again, it was limited in scope and in view of that snapshot of the period that occurred in May of 2023, and it was not decided until a full year later, frankly, and a lot had changed. And it wasn't just the position of the children, it was the goal of the department for those children also changed. When the father stipulated to the determination of his rights, the goal was adoption versus it being reunification at the start of the
Counsel, could I ask you a question on that? At the time the fair hearing decision was made, the children had already been taken from the grandmother's custody to the maternal aunt in Canada, right? So I guess the problem that I'm having is the argument is being made that because of circumstances beyond the grandmother's control, that the department did, all of this evidence was adduced that militated in favor of a new best interest determination against the grandmother. Whereas if the children had not been taken from her custody and continued to be in her care, and we had the same type of evidence that was adduced at the fair hearing about how the children were doing, ostensibly it could have been that the decision was to maintain grandmother having custody.
potentially.
Potentially, but you're arguing, both the department and you are arguing a circumstance that is completely something that grandmother had no control over.
Well, I would say, Judge, that when the department overrode their stay and placed the children in Canada with the aunt, grandmother did file for declaratory relief there too with the justices. She was denied. She did try. She was denied. And at the time, the children were in support of that move. These are their stated positions. This is not substituted judgment. The children did not want to reside with grandmother. They do not want to reside with grandmother now. That has not changed. Their position has not changed. So there's nothing to say that at the point when the goal for the children from the department was reunification, because it was still so early on in the care and protection, that by now, whether or not the grandmother would have been even a pre-adoptive resource for these children, because their goal was at that point adoption, so their permanency goals have now changed. So the needs of the children have now changed. What the department is looking for in a placement have now changed. That all changed in the pendency of this fair hearing. So to say that a fair hearing officer who has no evidence at all as to what is happening right now, what the goals of the children are right now, what their needs are right now, could order just the children to be placed back with the grandmother for a period of time, that period of time can lead to additional instability for these children. When the department has them in a place where they can find permanency and where their goal is permanency, the children are doing well, the children support it, and the grandmother has no standing to challenge that under the care and protection, which takes precedent. And I think that what we heard today a lot was how the grandmother was aggrieved, how the grandmother is suffering, how the grandmother has an injustice, but we're ignoring the children and their needs, and they have to take precedence.
Given the extraordinary facts in this case, would you agree that this is an incredibly dynamic, fluid situation with their placement?
And
That's really the elephant in the room.
That is the nature of care and protections, and I would ask this court to read that reverse language in a different way than you would normally hear it reverse. Because if we're talking about monetary recoupments, you can easily reverse that. You give the money back. If we're talking about land, that's easy. We give the land back. But these are children in child welfare practice where things are constantly changing. And you can't just say we can put the kids back, because what will that do to the children? And a Superior Court judge just simply does not have the facts and information before him to make the determination that placing these kids right now for any period of time is going to be in their best interests. You can't do it, and that's why the Superior Court had no subject matter jurisdiction in this case to make that decision.
I go back to that fundamental question. That's talking about the outward bounds of the relief that the Superior Court judge could afford. Isn't that a different question than subject matter jurisdiction?
I don't believe it is, Judge, because what can the court do if they cannot grant the relief requested? What is the power of the court? What are you going to do? You're going to say, okay, well, we would like this, you know, abstractly to occur, but sorry, you're back in the position you were. If the judge cannot grant the relief requested, then they do not have jurisdiction, because that is the necessity of having jurisdiction, is having the power over the parties to grant the relief requested. And if you cannot grant that relief, you have no subject matter jurisdiction.
Okay,
Out of time, so.
thank you.